Executive Director of the New York State component of the American Institute of Architects. I'd like to welcome you to Collaborative Leadership in Design and Construction in the Age of COVID-19. This session will run for approximately 90 minutes with time for questions and answers at the end. The program is being brought to you by the 14 New York region chapters of the AIA and the Associated General Contractors, New York State. The session is approved for 1.5 LUs for architects, and this will be applied to your continuing education necessary for membership in the AIA. The credit for this program should appear on your transcripts within 10 days. I'd also like to remind you that in order to earn credit for the program, you must be present for the entire session. Throughout the program, you'll see 5 words that appear in the PowerPoint and chat box at various times. Please take note of these words as you see them. You'll be required to write them on your CE card that will be provided in the chat at the conclusion of the program. Please fill this card out and return to us no later than this evening at midnight. The card is digital and it will give you all of the information you need to earn your CE credit. Questions and participation throughout the session are encouraged. If you have a content question for the presenters, use the Q&A box at the bottom of your screen. If you're having any technical issues or have a question about the webinar itself, use the chat icon at the bottom of your screen, and we'll do our very best to answer your questions. I'd like you to please be aware and please note that the information provided during this webinar does not and is not intended to constitute legal advice. Instead, all information, content, and materials available during the webinar are really for general informational purposes only. In these uncertain times, the way architects, construction professionals, and attorneys collaborate on projects has become way more complex. Communication between all parties is key to keep everyone informed and moving in the same direction. And contract provisions and language has really become the centerpiece in mitigating risk. Collaboration and communication is absolutely imperative. Our panel of experts will share their experiences and provide you with some best practices on navigating the challenges and issues you are facing in the age of COVID-19. Before we begin our session, I'd like to ask Joe Hogan, who is with the Associated General Contractors of New York State, to say a few words. Joe, you want to chime in, please?
Thanks, Georgie, and welcome to all of you participating today, and thank you very much to our moderator, panelists, and moderator I'll introduce in just a moment. Last year, AGC and AIA held a series of panel discussions in various parts of the state about the importance of and designers can and should communicate and collaborate better for successful projects. Given this current crisis, it's I think more important than ever. We've heard from some clients, some owners about the importance of this. It's going to be important not just for the projects that are ongoing, but for projects in the future, in the near future, to make sure that when this is all over, we as an industry can hit the ground running and really be the engine for an economic recovery that's going to be very, very necessary. With that, it's my pleasure to introduce our moderator, Kelly Hayes McAlonie. Kelly is the Director of Campus Planning at the University of Buffalo. Kelly, thank you.
Thank you, Georgie, Joe, and Mike. for organizing this wonderful session. I too would like to welcome everyone to our session and appreciate the time you've taken from your busy schedules to join us. Our webinar will look at at this issue in three main topics and provide you best practices or beware tips for each of you to use as a resource. The three sections are as follows. Number one, what happens if your project is going forward? Number two, what happens if your project is shut down? And number three, what about those projects that will be bid in the next 60 to 90 days? At this time, it is my pleasure to introduce today's speakers. I would like to welcome Jim Barriere, who is an attorney and partner with the law firm of Hinckley, Snyder. Joe Lipsky, operations manager of Lipsky Construction. Tara Mulrooney, an attorney and partner with the law firm Zetlin and Chiara. Kirk Narburgh, CEO, managing partner of King Architects. Michael Spinelli, an attorney and president of Nassau, Suffolk Engineering and Architecture. He's both an architect and an attorney. And Carl Stewart, vice president and general manager for Turner Construction. So with these introductions out of the way, let's begin. The first topic, as I mentioned, is the here and now. The project is proceeding. And my first question is to Carl Stewart and Kirk Narburgh. Carl and Kirk, what are some of the strategies you have utilized in keeping a project open and deemed essential?
I'll begin with that one. Good morning, everyone. It was good to see that I could still find a jacket and a shirt after the last month. So no hoodie today. I had to put a jacket on for the video presentation. So there's a couple of things that come to mind in terms of strategies that we had to implement in keeping the projects moving forward. The first thing we knew early on was that we didn't have a plan. So our number one strategy is we need a plan. We didn't really understand what was happening. And as one attorney described it to me, it was kind of like building an airplane as flying. So what we started out doing is we created some task force in our leadership, and we separated them in a task force that was dedicated to understanding the safety and what we had to do to move forward. There was another task force on the leadership of the risk management and legal aspects of what needed to happen there. We put another one together on the logistics of what was happening at the job site, and not only there and at the offices, and what it was like to work remotely. And then HR started to track what was happening with personnel, and this was especially needed down in New York City, where it was an epicenter of what was happening, and the crisis was definitely trying to blow up there. So we put the strategy was put these groups together. We started to talk daily in the morning and then in the afternoon, and pretty much it was the plan, do, check, adjust, and what was happening and what we needed to do to move forward. So that communication was absolutely critical. I can tell you for like 2 weeks, it seems like that's all the leadership at the company did. Even all weekend long was kind of react to what was happening within the industry and putting a plan together. We started to focus then on some of the CDC guidelines that we needed to do to implement at the job sites to keep them open. So now the logistics as they used to be were no longer, how do we do this social distancing? What's happening with PPE? And we went from dedicating and donating our PPE to now trying to find some to protect workers. So that was interesting. So having that task force and a plan, understanding what was required of us was important and difficult at times to understand. And then there was the components that we started to implement to try to make the site safe, like temperature and checking temperature. One of the things that we knew about this virus was one of the early warning signs was a temperature increase. So there was no protocol. We didn't know how to keep workers safe. We didn't know how to read. We were buying things that we didn't really end up using in the end because we just didn't know. Again, we were figuring it out. So we put some temperature protocols in place. So we wound up after about 2 weeks of putting a plan in place, but it took all of our leadership and a tremendous amount of time stopping everything else we were doing and working on that plan. The second strategy was trying to get the teams to move forward, because it was kind of like a paralysis by analysis. No one has ever been through this before. So we had our owner saying, hey, this is not on us. This is on the workers. This virus comes in on the workers. we had the workers saying, hey, we're here to the benefit of the owner in building their buildings. So there was a lot of discussion that went back and forth as to, okay, how do we move forward? And in unprecedented times and without really a lot of background on this, look, we just tried to approach it fair. We tried to say to the contractors, subcontractors, Turner we'll take care of the workers. We had asked our clients to possibly look at some additional wash stations and logistical items that kept social distancing and keep track of all the time and cost, because it may be sorted out at the end. But we didn't have time to sit there and fight about it. And even contractually, we can't stop. So we basically said, let's come up with a fair plan. Let's move forward. Let's continue with the project because it's deemed essential. And so that was important. And I think the third thing that comes to mind in terms of a strategy was absolutely the communication. Everybody was so nervous. So we put in processes in place where there was multiple emails going out, not only to professional staff, but to our trade workers. We had conference calls. We had the job site calls. We just said, look, we need to over communicate here so that folks are safe. We gave them an option, which says you can work or you cannot work. So I think that option gave some comfort because the decision was left with the worker. And I think lastly, we provided good resources for the staff. We gave links to the CDC websites, to EDC, to the executive orders. We tried to provide as much information as we could to our staff and trade workers to be able to be informed. And a great resource for that throughout this whole thing was the AGC, because I think we'll talk about it in a bit. It was really hard to try to understand what was happening in the industry.
Yeah, the only thing I would add to what Carl just mentioned was that, the initial stages were quite hectic. Everybody was in the same boat in terms of what was considered an essential project or not, and whether construction could proceed. So we were all in it together, as confused as anybody else. So I think the key of the presentation today is, and what we're going to hear from all the panelists, is the collaborative effort that's necessary during these very uncertain times to make sure we're all in lockstep as to a path forward. So, initially the essential nature of the project was kind of up front and center as to whether it could even proceed. It took a bit to sort out, but after a few days, it was obvious that we couldn't do it alone. We had to do it together as a team, the CMs, the architects, the contractors in many cases, as well as the owner, because in the end, it was the owner who had to decide whether or not they were going to allow things to proceed as necessary. So, huge collaborative effort on everybody's part to make sure that that happened, especially amongst all the confusion.
Thank you, Carl and Kirk. And just to remind our attendees that if you do have questions, you can ask them in the chat box. We will be saving time at the end for questions and answers. Question number 2 is to Joe Lipsky. So how have trade workers reacted to working on site in your experience?
Good morning, everybody. Yes, right now, what I would, to summarize this, is that I would describe the workforce across the state, particularly in the city and in Long Island, as a very unstable workforce. And by that, we have different classifications of workers right now. Everyone is affected by the COVID-19, as well as the governor's executive orders. And that really affects how progress is made in the field. And as everyone knows, like everyone, architects, engineers, construction managers, general contractors, we're all there to support the workers in the field. That's our primary function, is to support the workers, give them the information, give them the code, the drawings, the specifications for them to complete their job. But if we can't get workers moving in the workforce, and the industry slows down quite a bit. So right now we're faced with 4 types of classifications of workers. We have people who are not sick but want to work. We have people that are not sick but not able to work because they're deemed not essential because of the executive orders from the governor, because their employer just decided it's a bad economy right now, I'm just shutting my doors. Our third one is we have people that are not sick that just do not want to work. They deem it too risky for them to leave their own house right now. And that's just a moral and ethical decision that they make within their own families. And the last one is number 4, is that they are sick, or someone within their household is sick and they are not able to work because of fear that they'll spread it to their coworkers and everything. So in general, if you have those 4 types of classifications, it really is a very unstable construction workforce that we have right now. And as everybody knows, you need everyone. It's a completely 100% team effort for a construction project to come together. If you don't have the electrician running the wires behind the walls because his whole crew is out, you can't do any drywall, you can't do any finishes, nothing. And we are experiencing on Long Island, and I know that my colleagues are experiencing in the city, that there are contractors and sometimes even unions for a bit that are just shut down. They are not able to come to the job. They're unwilling to come to the job. And if they do come to the job to work, a lot of the subcontractors are not ready to have their workers work because they don't have the correct PPE. Hospitals are having, as Carl was saying before, hospitals are having a hard time getting PPE. And as a construction industry, we're also looking for the same PPE in some cases, which are just regular face masks, goggles, gloves, and that is more essential in the hospitals. So it is a very, just to summarize this one more time, as far as the workforce at this current time, I think it's very unstable. I think it has to be taken day by day. It definitely changes. Every job that we have has changed dramatically. And a lot of our, we rely so heavily on the subcontractors that we often forget about them, but they also need to be factored into this equation as well.
Thank you. They are essentially reflecting the general population.
Yes.
As I hear it. Thank you. The next question is for Mulrooney. Chiara, this is a two-question section here. Does being deemed an essential project require performance to continue or merely allow it to proceed? And what if safety requirements and supply chain issues prevent or significantly impair the ability to safely perform the work and or adhere to social distancing requirements? Chiara?
Sorry, I still had my mute on. Thanks, Kelly. No, I think that's a very important distinction to be made. A lot of people realize that their project's deemed essential and, kind of are heads down, ready to work. And I think, some of the issues that Carl and Joel spoke of, make us realize that there's still issues even if you can work. And I think it's important to note that the Empire State Development did put out guidelines basically saying that essential construction may proceed. So it's more of a permissive, and I think further on in the guidance, it even goes on to say that at every site, it is required that the personnel working on the site maintain an appropriate social distance, including for purposes of elevators, meals, entry, and exits, and that sites that cannot maintain appropriate social distancing, as well as cleaning and disinfecting protocols, must close. So even though you're deemed essential, you're still required to, make sure the safety of the workers are protected and make sure that you can, adhere to some of these guidelines on social distancing. The CDC has guidelines that says you have to be at least 6 feet apart. There's requirements for PPE. There's also, in New York State, there's prohibited gatherings of over 50 people. So all of this does have implications on the ability to move a project forward. As Joel mentioned, every worker is essential. So not having certain workers be able to be there or having to downsize shifts because you need to maintain social distancing, all will impact the projects. So that's an answer to your first part. To the second part, I think, again, you're going to have, because of workforce issues, because of supply chain issues and availability, there's going to be direct impacts on the project. So what I would advise is that everybody involved be really, it's really critical to review your contract and make sure that you're familiar with and strictly following any notice requirements, because you're going to want to make sure you're noticing all your claims for increased costs. If you're a contractor, if you're an architect, you might have additional time, you might have claims coming in, you're acting as an initial decision maker, that might be outside your scope. You're also going to have schedule impacts, even though the project is moving forward. So I would say for, you know, contractors, make sure you're following your change order protocols, which are, you know, if we're using the AIAs, the general conditions, A201, Article 7 generally governs that. Make sure you're following, you know, notice requirements set forth relating to time, claims for additional time. Our section 8.3 really governs delays under the A21 general conditions. So be aware of that. Be aware of timeframes that have been negotiated in. Often you're required to give time notifications within a certain number of days, or you might waive your claim. So that's really important. For architects, Article 4 of your B101 generally governs additional services. It usually requires that you know, give notice with reasonable promptness. So these are things that you need to make sure that you're aware of. And also that you're sending out notices in the method prescribed. I know we want to send everything by email now just because people are working remotely, but still make sure you follow kind of notice procedures and copy the people that need to be copied. Under the general conditions, you need to copy the initial decision maker. So make sure that you're aware of these things and following them as the project goes on.
Thank you, Chiara. This is great. For those of you who do not have access to the video, the first word that was shown was collaboration. Moving on to the next question is for Carl Stewart. Carl, what is the position of the labor unions on continuing or resuming work? And are they running opposite to the efforts of the agency?
First, let me state that had some exposure from Buffalo out through the capital region down into the city and out on to Long Island. At least in our dealings so far, the feedback from the unions is, as you can imagine, they want their workers to be safe. That's their first priority. And I think that's all of our priority, especially with the shortage of PPE. There's a lot of concern there. There is no known refusal to send folks here in New York State. I do know there is some unions that are in Massachusetts that have done that, but not in New York State that we're aware of at this time. I checked with everybody yesterday. So the approach for the most part in terms of labor has been more of a personal decision on the tradesperson than that of the union that they have. I can tell you the unions have been fairly accommodating, like even in the absence of a PLA. So things like reducing the concentration by allowing 4 10-hour days instead of 5 8s is something they're doing. Staggered break times and lunch times and staggered start times, again, are typically something negotiated in the PLA, but they're happening on job sites because they just want to reduce the exposure that the staff have. There have been some requests for hazardous pay for some of the trades persons, but it hasn't really been pushed hard yet. It's just been a discussion point, and to date, that hasn't been implemented. There's an interesting component though with the enhanced unemployment insurance, because you're getting close to a breaking point. I think the breaking point is like $30 an hour that you can actually stay home and make the same amount of money. So workers from a perspective may want the job site shut down because they can now go home with no waiting period and get almost the same amount of money that they would make working and not be exposed to the virus. So as you can imagine, that adds a very interesting dynamic to the availability of labor and who's willing to work. With respect to how are the unions in the efforts of the AGC, I mean, the unions, they exist to protect their members. So they want them safe and they want them to work. If I were to summarize the feedback that we'd have, it's pretty divided right now amongst the unions, and it would probably go like this. Half of the membership don't want to work and the other half have to work. So as you can imagine, that's creating quite a dynamic in amongst the unions. So they're trying to do their best to support. But just like the AGC, the unions want work to proceed if we can do this safely for those involved.
Thank you. The next question is for Michael Spinelli. Michael, how does an architect respond to an employee who expresses concerns about entering a job site to manage his or her typical construction administration duties?
Thanks, Kelly. The first thing I think we need to point out is that many of the national firms have already instituted policies for no travel or no site visits or restricted site visits. And many have done that before employees have come forward and either expressed an unwillingness, a concern, or a refusal to visit. And while this webinar is not intended to be a primer on employment law, and the other attorneys will discuss more of the legal issues, I would not recommend that any firm force any employee to visit a job site. I would not want to be the test case for that, and I suspect there will be a lot of new law coming out of this pandemic. So I would not do that. Next, I would identify the issue in terms of having the conversation with that employee. What is it specifically that they are concerned about? Are they worried about being, let's assume it's essential construction. Are they worried about being in a small trailer for a job meeting? I have a lot of essential infrastructure projects going on right now where we're meeting outdoors. Is there concern the touching of surfaces on a job site? We're bringing in cleaning crews every day to clean. Or is there concern the commute to and from the job site? We are renting cars for some of our employees because they do not want to use mass transit. So I would try to the extent that you can to figure out what is the nature of that concern and try as best you can to resolve it if you can. I would also look to that concerned employee for the potential solution and ask, how do you think you could do the construction administration tasks here from the office? Let's hear what they have to say. You know, ordinarily most firms are run by the owners, the partners, and the senior associates. Here, it is a lot of the junior associates that are helping us embrace technology. I get worried that I'm morphing into my father and my VCR is going to flash 12 o'clock for the rest of my life. A lot of the technology that we're using now, it has been the younger folks in our firm that have come to us and said, here is the way that you can do something by using current technology. And lastly, we already do a lot of this stuff remotely. Certainly architects go to job sites for weekly meetings, but much of what we do is done remotely. We review drawings, we review details, we answer correspondence, we engage in telephone conference calls. All of that can continue to go on. Now, we've talked about this as if the unwilling participant is an employee of our firm, and we have the ability to assist that individual. Sometimes the unwillingness will be on another team member who doesn't want to come to the site. And I would suggest that we adopt some of those same strategies for finding out how we can get perhaps employees of other firms to participate. But I think anything that we do always has to be viewed through the lens of reasonableness. I don't think we should be insisting or demanding that somebody has to come to a job site.
Thank you. Thank you very much. And the final question in this section is for Jim Barriere. Following, I think, a good follow-up to this last question. Jim, are PDF payment applications and change orders legally acceptable and enforceable without original ink signatures and notaries?
Thank you, Kelly. So let me answer the question legally, contractually, and then practically. Legally, with the advent of email communication, that we saw over the past 2 decades, there are a lot of court decisions that have come out to discuss this concept of whether there's mutual assent through electronic communications. And by and large, the courts have found that if the communication evidences enough of the elements of an agreement or a mutual assent to an issue, they'll enforce it. So we have e-signature cases in New York State where courts have recognized that that constitutes mutual assent. When we think about this in the context of the AIA and other contract documents, many times they require more specificity with respect to the formality. They may require a notarial stamp. They may require a signature, on a change order or on a pay application. And this is where we get into, notions of contractual force majeure. As we all know, force majeure is an excuses performance, strict performance. And the issue would be whether or not the fact that you can't physically get something signed and mailed, or you can't get something notarized because of remote issues, does that excuse performance on that level? And I would suggest that you really don't even need to have the argument, because we come to the practical consideration. Michael and Kirk and Carl and others on this call have talked about collaboration, have talked about being reasonable, have talked about being aligned with respect to how we're going to approach performing these projects and getting the work done. And in my view, this is a very good example of the communication that's needed at the project team level, where the contractors, the architects, the owners are talking about, hey, as a practical matter, how are we going to handle the payout process? Do you really need them signed, or will you accept an electronic signature? Can we forego the requirement of going to a notary? Same holds true for change orders. So I guess my ultimate answer to the question is, I believe they are enforceable, because I believe they can be used to show mutual assent in terms of the e-signature. But the best practice and approach is to make sure you're communicating with the folks that you're submitting bills to and who are reviewing those bills, so everybody's on board with the manner in which the process is being followed.
Thank you very much. We did get one question that I wanted to direct to Carl. It was more a question for clarification on your last question. Carl, one of the participants asked you to clarify your comment about potentially people wanting to, they understood your response saying that you thought that workers may wish to stay home as opposed to go to work. And I did not hear that. I'm sure it's not what you intended. If you could just clarify that.
So there has been a lot of discussion with regards to what would be enforced in this unprecedented time or not. Technically, if a worker refuses to work, that they're quitting their job and they're not entitled to unemployment insurance. So they can elect to not work, and then they could apply. The question becomes, will the state deny them or not, given the certain circumstances? And I don't have the answer to that. We have seen all scenarios come across where there have been people that just refused and then applied. There have been, and I haven't seen any output from that yet. And there have been those that have said, okay, I'll continue working. So if the question was that I'm saying they can elect to go do that and get unemployment, that is yet to be determined. I think my point was, I think many of them would like to see the job shut down, because if the job shuts down, then there's a layoff, and then there's no question that they could go and have unemployment insurance.
Thank you. We can move on to the best practices for this first topic. And they are as follows. The alignment between owners, architects, and prime contractors is crucial, so that expectations with regard to the progress and completion of the work are clear. The project team should have candid discussions about the work site, workforce, and material procurement challenges, flexibility, and realistic goals. Number two, once alignment is achieved, communication should be from the top down, so everyone knows that the owner and the design and construction team share the same goals and values. Number three, set up a template or dashboard on SharePoint to track required information. Number four, track notifications, daily work plans, costs, and reimbursement. Number five, be aware of and strictly adhere to any notice requirements under your applicable contract. For contractors and design professionals, even if work services are proceeding, the project schedule and cost will be significantly impacted, even though the project is not entirely shut down. Make sure you are documenting and notifying all potential claims for increased contract time and costs stemming from the COVID-19 outbreak, such as schedule implications resulting from the scaled down workforce due to social distancing, as well as availability issues and increased costs for materials resulting from disruption in the supply chain. Thank you so much. We're going to move on now to topic number 2, which is titled, Beware, the Project is Shut Down. My first question of 5 is directed to Kirk Narburgh. Kirk, what are some of the challenges with a project being shut down and some of the opportunities?
So I think there's 2 major challenges. I think the first one is, what is exactly a project shutdown mean? Because we all know that projects aren't completely shut down. They're, in the most part, partially shut down. There's still a lot of activities that might be going on, that could be going on in the background. One of the biggest ones is, supply chain. So, we can't stop en route materials coming to the job site potentially. So somebody probably most likely is going to have to be available to accept those things or reroute them to other locations. So, there's the whole logistics side, which really falls under the, kind of CM and contractor realm as to how we keep, activities going in the background while construction might be shut down. The other most obvious one is the schedule. So I know we all have had experiences with project shutdowns and what that means to the schedule. Not like what we have now, where we might have multiples of these happening at the same time. I think as we've heard from a lot of people so far, it's one of those efforts where everybody's got to sit around and figure out what's the critical path, because we've all spent usually with the owner and the CM and the architect design team, we've spent most likely close to a year trying to figure out those schedules, right down to the day or month in terms of activities, so that we can have the project open. So now we've thrown that all out the window. We need to start figuring out, what are those critical paths as a team, and what does that mean? We're all smart. We've been down this road before. We just need to get together and really explore those what if statements. And I'll give you one example that has been really problematic, is that there's so many different permutations about how this all can happen. And what those if then statements might mean. But in the school market alone, we're looking at the prospect that potentially job sites can keep moving with an empty building, because the students and staff are predominantly not in those buildings. And right now it's on the table that schools might be back in on the 29th. So we've been looking at kind of the critical path of what if related to, when we get to the end of the month and we're allowed to work again, potentially, are we going to have an empty building or buildings, or are we going to have to work around trying to make up scheduling items, or, work with a schedule with an occupied, building scenario. So, it's one of those things that has a dramatic effect, obviously, but, we should be using this time during shutdown to work through those more than ever, because, we want to be in a good place to hit the ground running when things open back up again.
Thank you, Kirk. Second word of the session is risk. The session was brought to you by the word risk. Okay, question number 2 for Tara Mulrooney. Tara, does the suspension of work required by Executive Order 202.6 constitute a force majeure event?
Yeah, that's the million-dollar question. And my very lawyerly answer to that is it depends. It's really going to depend on what your specific contract says. I think it's helpful to kind of look at the AIA documents and guidance as kind of like a starting point where a lot of products are working under, or, you know, these terms may be slightly modified, but what the form documents provide is basically they do provide kind of force majeure protection, excusing performance for something like the COVID-19 outbreak. For the architect, under the B101 2017 version, section 3.1.3 basically provides that once the owner has approved the schedule for the architect, that the time limits set forth in that schedule shall not, quote, except for reasonable cause, be exceeded by the architect or the owner. So I think it's pretty fair to say that this would constitute reasonable cause. I think one thing to be wary of is that this term can often be modified because, you know, schedule and timing requirements are definitely a heavily negotiated point. So be aware of whether or not you have specific timeframes and notice requirements that you're supposed to, you know, provide notice within that timeframe to the owner that you're anticipating delays. And I would also recommend that, you know, as you learn more information, you can update the notice and you know, provide more background information and kind of flesh out your claim a little bit better. Under the contractor agreement, there is force majeure type language under section 8.3.1, which generally provides that if the project is delayed due to labor disputes, fire, here's one that's applicable: unusual delay in deliveries, unavoidable casualties, adverse weather conditions, and it has a catch-all similar to the architect's agreement, providing or other causes beyond the contractor's reasonable control, then the contract time shall be extended for such reasonable time as the architect determines. In terms of notice and when that notice has to get in under the AIA form, you have to comply with the claim provision, which is under Article 15. And unmodified, that provides for both owners and contractors to provide 25-day notice of any claim. And that claim would be when that period would run would be basically from when you first have knowledge that there's a delay or the event giving rise to the delay, whichever is later. So again, I just want to stress that this is a heavily negotiated provision, especially in contractor agreements, and you know, courts tend to enforce what the parties have agreed to. So, you know, really review that to make sure, number one, whether you're covered, and number two, if you have notice requirements, and if you fail to meet them, if the failure to do so might, you know, be a waiver of claims. So it's really important to kind of follow that, to really be aware of what your contract requires.
Thank you very much. This next question also deals with AIA contracts. This question is for Jim Barriere. Jim, it's a two-part question. What implications does the suspension have on the rights of each party under the AIA contract? And does the suspension provide grounds for termination? And if so, what compensation is required to be paid as a result of such termination?
Okay, so let's talk about this in the context of AIA 8201. And then I'm going to provide some comments on some owner consternation in the issue about, in the industry about suspensions. But first, when we talk about AIA 8201, what we're talking about is section, Article 14.3. And under Article 14.3, the owner may order in writing to suspend, delay, or interrupt the work in whole or in part for such period as the owner may determine. And in that case, the contract sum and time shall be adjusted for increases in cost and time. So if the owner is ordering the suspension, AIA 8201 provides a mechanism by which the contractor can submit for additional time and additional cost. And to Tara's point, you should be mindful of Article 15 and what that says with respect to the timeframes within which to do that. And if your request is denied, of course, you've got to go through the rest of Article 15 on the initial decision maker process and the follow-up notices that are required thereunder. So that's it for AIA 8201. The owner may order in writing, right, a suspension. We're in a different place now because in many cases, the owner is not ordering any sort of a suspension. These suspensions are coming from another area. And again, to Tara's point, that brings us under 8.3, which are delays and extensions of time. And I will not repeat what she just told you there because it's perfectly accurate and it's what you should be doing. But there's an issue in the industry that I want to point out to the listeners, and that is, unlike AIA, many public owner contracts and some private ones provide that if there is a suspension for over a set period of time, i.e. 30 days, any party to the contract can invoke a termination for convenience. And in the typical termination for convenience clause, the recovery is basically the cost incurred to the date of the termination for convenience, less payments already made, and many of them provide for reasonable demobilization costs. The concern in the industry is that on many projects right now that have been impacted by the pandemic and that have been shut down, owners are concerned that contractors who maybe weren't doing very well on the job before this crisis hit, and who really don't want to finish their job because they don't see it getting any better financially for them, are going to invoke these clauses if the suspension lasts more than 30 days. And they're basically going to be stuck with a termination for convenience that's authorized under the contract. I've heard this from many owners. Candidly, I've had contractors call me about it because they're considering it. And I just want to make people in the industry aware of it because it all goes back to what we've been talking about all day today, which is collaboration, communication. If you have a clause like this, it's non-AIA on your project, and you are worried about continued performance on the other side of this pandemic, you really need to be talking to your contractors. You really need to be talking to the folks that you're in business with to make sure that the commitment level is the same at the end of this as it was going into it.
Thank you, that's very helpful.
Kelly, can I just make one point under the AIA that's very, very valid, and they're under the AIA, one section in that regard to be aware of is section 14.1.1, which goes into that 30-day suspension or 30 days where work is stopped. And it specifically provides that a right for the contractor to terminate if the work is stopped for a period of more than 30 days due to an order of a public authority, which, you know, we have here with Executive Order 202.6, and then or another area could fit in is if it's stopped due to a declaration of a national emergency. So under the AIAs, it's also something to be aware of, that it gives the contractor a right to terminate. And under the AIA, I believe the 2017 version, it also provides for reasonable overhead and profit unperformed work. So it is something that both owners and contractors should be aware of.
Thank you for that clarification, Chiara. Third word of the day is punch list. So our next question actually is for Chiara Mulrooney and Michael Spinelli. It's a two-point question again. What are the ways you can keep a project moving forward during project suspension? And are there services and functions architects and contractors can still perform while work at the project site is suspended? Chiara and then Michael?
Yeah, I think Michael alluded to this earlier. There are definitely services that can still be performed while the project site is shut down. In the CA phase, that would be for the submittal process, really, the review of submittals and responding to RFIs. Virtual meetings can be held. One thing that I think is really important is to have open communication and collaboration in this area. And, you know, I think it would benefit both parties to kind of brainstorm what can be done while the project is stopped, and kind of create a schedule of services that can be provided on a weekly basis, on a monthly basis. Maybe negotiate what the payments would be for those services ahead of time, to kind of keep the project moving forward and keep everybody kind of aware of, you know, what they're going to be paid for, what they're responsible to provide.
Yeah, I would also suggest that you keep an eye on the guidance that's coming from Empire State Development. It has been updated a few times, and the category of projects that are now deemed essential is getting broader. I believe the most recent guidance now included both public and private schools as essential infrastructure when that was not in the original guidance. Also, as a practical matter, I have seen several projects that were not expressly included on the list of essential infrastructure, where application was made to ESD, and within 24 hours, designation was granted for that project to be deemed essential, and they moved forward. I am certain there are projects that have made application and not be granted, but I have not seen one yet. So I would look again at the guidance, and if you can, in good faith, argue that your project will ultimately result in an essential service or essential infrastructure, I would make application, and I would see what Empire State Development says. I would also remind you that even if your project is not deemed essential infrastructure or essential service, you can still stay on the site and make them safe. Nobody wants to see your project left in an unsafe condition. So even if you are not an essential infrastructure project, I think you should make sure the site is safe and there are contractors on site doing that. But now really is the time for planning. In my career, I can't think of a single time when I've gone to a job meeting and every one of the project participants didn't have some list of items, some ball in their court that they needed to follow up on. If you are a contractor, now is the time to get all of your submittals in. Now is the time to make sure your coordination drawings are done. Now is the time to buy out the rest of the project and finish your shop drawings and submit those RFIs. None of us like the paperwork end of the project, but without it, the job doesn't move forward. And you have a wonderful opportunity, now that we're all stuck at home, to get that paperwork out of the way so we can hit the ground running. On the flip side of that, as the architects on the project, now is the time for us to review all of that paper that's coming in and provide those answers and provide that guidance, so that when these projects do start back up, we're not answering questions 6 weeks from now that we could have answered today. So I would suggest that now ultimately is the time for planning and addressing the ministerial paperwork items that unfortunately can lead to project delays. And finally, if you have been impacted on your projects, the time to prepare your extension of time request is now, not 6 months from now. Now you know in real time what is happening. Now you can document contemporaneously how you have been impacted. The time to prepare that extension of time is today, not 6 months from now, where it will be more difficult and more expensive to look back and document those delays.
Thank you very much for that, Michael and Carl. And one last question in this section is for Joe Lipsky. So what are the provisions and procedures that employees should create to document during the COVID-19 crisis?
Yes. So Tara touched on this briefly. She talked about provide notice. And for any contractors out there, this is like key. If you want to have any chance of even attempting to recover or put a claim in, you have to provide notice. That is like the most important thing to start the process. It's like everyone wants to know, it's like, how do you start anything? And the first thing you have to do in an AIA is follow the contract and to provide notice or notification. And the method that you do, the vessel that you use to provide notice should be a transmittal with a letter. And transmittals, I have this fight a lot within my smaller company, because this is something I learned over at Turner when I worked for Turner, is that everything should have a transmittal on it to a reasonable degree. Every payment application, every submittal package that you put on. With that vessel and that method of transmittals, you should also provide notice to your owners and your architects of the COVID, even if that means you are not aware of the extent or the cost impact that you're currently faced with. Fortunately for me, I've had some very good mentors. And my father, who has a lot of legal, very heavily legal background, and my aunt. I've also worked for Turner and their claims and cost department, so I have a fairly good understanding of how this works. But the most important thing that you need to do, if you even want a slim chance of success with your attorney fighting this for you later on, is to follow the AIA and to provide notice and reference the area of your contract where it says that you need to provide notice. All right. We just sent one recently to an owner, and I don't have the extent of the claim or potential claim. And I just want to add one thing, just because, and construction managers don't really like notices of notices all the time, but the intent of the notification is just to provide. It doesn't mean I'm going to necessarily do something. It just says, hey, I'm obligated under my contract to provide you with a notification. So I am doing that. Now, if I decide to pursue that as a claim or not, I can do that later on. But the first thing that you have to do is to provide the notification. And we just sent one recently that pretty much in summary says, although the full extent and the impacts of the delay arising from this matter are not currently known or measurable, we're anticipating the impacts of the project supply chain differently than what we bid this project on. So the one I sent out recently to an owner, just like a blanket statement. I don't know how long this is going to be. All I know is that it is 100% going to affect this project. I cannot measure the time, I cannot measure the cost, but through the vessel and the procedure of the transmittal, I am providing you with notice. Along that same line, I know there's a lot of employers here on the call. If you're an employer, it is very, very good practice to, with all the furloughs and layoffs and the CARES Act, when you lay people off, if you're going to furlough people, if there are people sick within your organization that got sick on the job, you should be providing notifications, even inter-office notifications of all these activities, so that if you get in trouble with the New York State DOL later on, you have a transmittal for every person that you potentially laid off, furloughed, just so that you can keep track of the dates of when things were sent out. I know that this question was specifically about owner contracts, not necessarily employees getting sick, but the transmittal is the most important thing that, and the biggest vessel that you can use to transmit a notification.
Great, thank you very much, Joe. It's very helpful. So our next section is called Best Practices, Beware. So these are topics to be aware of in under this section. Number one, review contract suspension clauses and procedures. Many suspension provisions give parties the right to terminate the contract for convenience after a defined suspension period, such as 30 days. Carefully review your contract for all relevant provisions, which include terms governing the schedule, delays, change orders, additional services, termination rights, notice requirements, and dispute resolution procedures. Remain acutely aware and observant of available remedies and obligations required under your contract, and ensure that you strictly adhere to all notice requirements to avoid waiving any potential claims. Number three, consider agreeing to a work plan setting forth the services to be performed over the next week or month and the payments to be made for such services. Do this on a weekly or monthly basis for the course of the suspension. Number 4, create daily work plans documenting what work is being done on site and as well as remotely. Number 5, review daily and or weekly work plans with your clients. And number 6, create a startup plan. So finally, we're moving on to section number 3, which is called Looking Down the Road, 60 to 90-day bid opportunities. So the first question is for Kirk. Sorry, there are 3 questions in this section. Kirk Narburgh. Kirk, what are some ways to maintain quality control and coordination consistent with pre-COVID practices?
Yeah, so we all know going into this that we were looking at one of the biggest volumes of bidding in spring of 2020 that many of us have ever experienced, just because of a great economy and a lot of work going on. So we know that there was a lot of work in design heading towards bidding. We had a lot of stuff that bid in you know, the September through kind of January, February timeframe. But just because of the pure mass of projects that were out there, we were still looking at projects bidding all the way into summer. So, you know, coordination and quality control is always of utmost importance, obviously for our owners, but also as the designers of record, and to, you know, have a successful project. It's of great benefit to the contractors as well. So, you know, we missed, I know that first week of shutdown for everybody was very hectic. We were uncertain as to what was going on, so people were literally leaving offices with whatever they could carry, not knowing if they were going to be back anytime soon. And we also know that, you know, we in many cases were caught a bit flat-footed in terms of how nimble we might be with technology. Michael talked about that a little bit before. One part of it is, you know, which is good in our industry, is we're used to, in a lot of ways, a lot of remote activities, so we're fairly well prepared. But the technology aspect of it, not so much. We had to open up data pipelines because, you know, we deal with large data files, and you know, when even if in PDF formats, they're a bit of a struggle to move back and forth from remote locations. So it took us a bit to get that worked out and get back to, you know, some normalcy. But you know, we're an industry where face-to-face discussions still are optimal when it comes to coordination and quality control. Having the entire design team and consultants together is the best way to kind of make sure that you've got everything buttoned up before you go out and put stuff out on the street for bidding. It's not the same looking at a PDF drawing on a computer screen as it is having some tangible documents with a group of people kind of moving back and forth. But again, you know, there's technology out there that we're comfortable with, like Bluebeam and other things, where, you know, we can do that collaborative effort online. So I think the initial phase was a bit of an adjustment, but we're kind of working through that right now, having our virtual meetings, which, you know, may have opened up a new pathway for the way we work in the future, because they are working. We've seen some benefits to be able to actually get together more often than even if we were in the office, because everybody's scattered and running all over the place. I think the area of biggest concern is things getting missed, because we aren't right there in real time to make sure everybody's got the guidance they need to follow up on tasks. And so it's real easy to kind of miss pieces and parts of things. I've got project managers, as we all do, that are, you know, working from home, potentially with a spouse or partner who also is working from home. Their pets are barking, their kids are doing homeschooling. So they're in the middle of a task, or, you know, buttoning up some detail or something, and all of a sudden they're getting distracted to something else. And so, you know, those are the big challenges we have to overcome. But I think all in all, after that transition period, we're actually probably back to working in a pretty efficient way in terms of that coordination and quality control effort as we were going into it. So I think there's some great lessons to be learned out of this. And if anything, it's made us a bit more hypersensitive to keeping track of all those little details that may fall through the cracks and being on top of them.
Thank you, Kirk. And actually, I think you bring up a really great point that maybe in a year or two, we should all reconvene and discuss how our practices have changed.
Exactly.
For the better, I hope,
Yep.
because of this the social distancing pandemic. Question number 2 is from Michael Spinelli. Michael, once a successful bidder is chosen, what can you do as an owner to help protect against the issues arising as a result of the COVID-19 outbreak and as a contractor?
The first thing I would say is that because the contractor has the most control of what's taking place on the site, it is ordinarily the contractor that is responsible for site safety. So I would make sure that if there has not already been a published site safety plan in place on the site, that you get one quickly, and that you work with a professional site safety monitor, and that you post that plan and make sure it's in compliance with CDC guidelines and any of the other experts. I would also make sure that there are routine toolbox meetings held with all of the trades, obviously far apart, and that what takes place in those toolbox meetings are reduced to minutes and that they're put on file. I also think, and on many of our projects, we're bringing in professional cleaning companies to clean the sites in the evenings. I also think we have to be more creative. What do I mean by that? I said earlier that we should speak to our team members and find out what specifically concerns them about going to sites, because perhaps we can delay some of those concerns by our actions. Well, the same thing I think can take place here with owner and contractor, where ordinarily if there's an issue on the site and the owner and the design professional and the contractor and the subcontractor may visit the site together and look at an issue to resolve it, well, perhaps this is a time for job sites to be open longer hours and off hours, so the same project participants can view the condition. They just don't have to view it together. So I agree with what Kirk said, that you can look at things on video and in photograph, although sometimes you actually have to see it and understand it in more context. Well, you don't have to do it, though, surrounded by a group of other people. So I would consider viewing the job in off hours. I also think we need to speak with organized labor and the trade associations to find out what specifically has their members concerned and what we can do to make them comfortable to come back to the job sites. So a lot of this really does get back to anticipating the concerns and then planning for them.
Thank you, Michael. The next word that was displayed on the PowerPoint was work plan. Work plan with an S. The final question for this section is for Jim Barriere. Jim, how can force majeure language be leveraged in the contracts to anticipate the potential continuation of the pandemic?
Thank you, Kelly. Let's first talk about where the force majeure is found in the AIA 8201, which is at section 8.3, which Tara discussed a little while ago. And probably the most applicable part of that section to what's happening today are circumstances beyond the contractor's control. Now, in normal times, bidding a complex lump sum project is very risky. But because of what we're going through now and what we can anticipate as the after effects of the current pandemic, the contractors and parties bidding these projects need to anticipate further labor shortages, some serious material and supply chain issues, and even issues with respect to routine inspections and permitting approvals by local municipalities whose own staff, may be overwhelmed by the number of projects they have to process. So when we think about force majeure and circumstances beyond a contractor's reasonable control, these are areas that a contractor would be arguing to an owner are things that they really don't have control over. And there's a lot of uncertainty. And a lot of that uncertainty is going to find itself into the bid documents in terms of how contractors are forecasting what the price of these projects are going to be. Another point I want to make is, again, outside the context of AIA, many force majeure clauses in public agency contracts reference things like uncontemplated delays, or delays beyond the reasonable anticipation of the parties. When we talk about that kind of language in a force majeure, people in the industry really need to be sensitive to it, because if your force majeure says that there's an excuse of performance, except for things that you can reasonably anticipate, we're living in a new world now. In anticipating a pandemic or a wave 2 of this pandemic is not necessarily out of the question. So I would urge parties, as they're considering bidding projects moving forward, to take a close look at those force majeure provisions. And if you have an opportunity to discuss those with the owners, consider adding language like epidemic or generally circumstances beyond the contractor's control. So the parties' expectations are aligned with respect to what truly constitutes a force majeure and where one party might be able to take advantage of another because of what we're going through now.
Thank you very much for that. Our best practices for topic number 3 are as follows. Allow the contractors to ask that alternate materials equipment be considered prior to bid for those items that are not available or delayed by the crisis. Number 2, make sure design professionals have provisions to do this. Be forward thinking and drafting the contractor agreement with the successful bidder. Make sure you think about the potential impacts to the project resulting from the suspension and craft language in the contract to help clarify and protect your rights. So thank you very much for to our panelists for answering those questions. We have received some questions from the participants, which I'll read. Last word though is RFP. So another word popped up, RFP. So we'll quickly go through these questions. This question I think I'll direct towards Carl and Joel, but I encourage others to also submit. How do you keep a site safe while in shutdown mode? Do you still have a small crew looking after the project?
So from our perspective, we have, even in the early guidelines, it allowed for a single person to stay on the job site just for that perspective. There are different regulations throughout the state. The building department in New York has other requirements as well. So when we even had a non-essential project, it still allowed construction to proceed in a manner that we could safe off the project. So sidewalk bridges, rooftop materials, things of that nature, secured, get them off the building, get the building safe. And then we would have staff go there and at least one person and just monitor the job site as each day went past.
Same. I do a little bit smaller than Turner for now. And we just kind of have like the superintendent that has been deemed on a not essential job site, just kind of floating around to a few of the jobs, just keeping an eye on it for us, so that keep him employed and also keep him as our eyes and ears. Like Long Island, you don't need to have security 24 hours a day like some of the projects in the city do. We don't have to do daily inspections of safety or even daily scaffold. There's a lot of those things that we don't have to worry about on Long Island. So we just do what's reasonable, prepare for high winds like we saw yesterday, and just look at we're always looking at it from the public right of way and to protect the public, anyone that may enter the job site.
Great, thank you. We've received a question regarding personal protective equipment. I would like to know if there are specific recommendations on PPE for design staff going to a project site to collect existing conditions information. So they're specifically asking about N95 masks only, or should these be reserved for medical professionals? And also, what other PPE should be required for staff in the field? Goggles, gloves, visors, disinfecting wipes, etc.
Well, I'll just say, I will start off by saying that the governor has made it very clear recently that it is the employer's obligation and responsibility to provide his workers with this PPE. So even if you're an architect, I would imagine that the architect principal and the employer would have to provide this type of PPE to his architect, so that he can go in the field to do, existing condition or site visit review or whatever. With that said, I would just use, an abundance of caution and, as far as just, the mask, the gloves, and then even having like taking it off and putting it in a paper bag before you even get in the car, your car, like just got to take those crazy measures. And really try to avoid crowds. If you only need one person there, don't sit any more than one person. If you really need 2 or more people there, I would use a 10-foot rule with masks and gloves. That's kind of what we've been doing. And we do a lot. And like what Mike Spinelli was saying, there's a tremendous amount that we can do with just photos, that, from existing photos, from existing as-built, and from just, our history of the project.
I'll just add a couple things architecturally is that, back, a couple weeks into this whole thing, we made a office policy about visiting job sites, and then we eventually went to, no site visits for the time being type of thing. But we know coming out of this that there's going to be some guidance that's going to be coming regarding, that personal protection equipment that we'll all most likely going to have to use moving forward. I think the big dilemma for us right now is that we don't know what that exactly is going to look like. And plus many of these supplies, as Joel pointed out before, aren't even available right now. So it's going to be a bit challenging moving forward. But I think, Joel said some great things about the distancing piece. We've gone so far as to limit, once we get back into this, we're going to have people traveling to job sites independently, not traveling in cars together for the time being. So, just the other ways to do that. So we're going to be a little bit more lean with how we accomplish some of these tasks for the time being.
I would encourage everyone to go to the Center for Disease Control website. They've got some great recommendations, guidelines there, and that's kind of been the guiding principles, I believe, for a lot of the decisions that have been made in the past 3 to 4 weeks.
Thank you. One question follows up on this a little bit on site. There's discussion about cleaning daily, setting up hand wash sinks, etc. But who pays for those services? Is the contractor or the owner expected to bear this cost?
The projects I'm working on, the contractor and the owner have had a conversation. They work together as a team and they've split the cost. Every contract is going to have its own language. As I said earlier, ordinarily, the contractor is responsible for site safety. However, a project that you were awarded last year was probably not foreseeable. And we'd have a national emergency and a pandemic. So I think there will be plenty of arguments to be made by the parties when the time comes. But right now, it's more of a time for teamwork, reserving your rights, and not fighting. As I said, we're splitting the cost between owner and contractor, and so far the parties have been happy to do that.
Great, thank you. Okay, there were a couple of questions earlier I wanted to address. We have a project where 75% of the trades are working, but 25% are not. And the working trades have indicated they wish to claim for a delay. Any ideas on how to manage the situation regarding delays due to non-performance of the other trades?
Yeah, I'll take that one, Kelly. I would suggest that in those situations, you have to look very closely at what your contract, compensable delay, excusable delay, and notice provisions say. And all these contracts are different. You just need to make sure that you're noticing early, that you're following those follow-up clauses, and you're making sure the project team representatives are aware of what's going on, because it's sort of double-edged. On the one hand, you've got issues based on their non-performance. But if you're a follow-on contractor and you need their work to be performed before yours is, you may have problems down the road to contend with. So it really is all about communication. Look, we work as a project team first, but we're also reserving our rights in the proper contractual way behind the scenes. And that's what we should be doing here.
Thank you. And Jim, there was another question I'd like you also to respond to. This is in reference to contractors who were underperforming prior to the pandemic. You discussed it. They asked, if an owner is having a difficult time with a contractor, can the owner terminate a contract after 30 days?
Did you say after 30 days?
Yes.
Right. So if it's in the AIA context, you follow Article 14 of your AIA contract. You put the contractor on notice of what the performance issues are. You give them an opportunity to cure as provided for under the provision, and then you proceed accordingly. I would add, however, though, that since this pandemic began, contractors are generally going to have most certainly more defenses to performance issues. So, you may very well have the contractor who was performing poorly before the pandemic and maybe didn't have many decent excuses or explanations for the failure to progress the work, come to you now in the context of the pandemic and say, wait a minute, my ability to cure is now significantly challenged because I don't have the laborers, I don't have the ability. So it's sort of fraught with peril right now to look to terminating for cause on contracts, because there will generally be more available arguments coming back in light of what's happening.
Great, thank you. This question is for Jim, Michael, and or Chiara. Section 8.3.1 of A201 General Conditions. The extension of a contract is determined by the architect. Any guidance on that? We extend based on the duration of the delay, allowance for supply chain impacts?
Well, I don't have 8.3.1 right in front of me, but to follow on what Jim said before about contractors having available to them additional defenses, perhaps for non-performance, and the fact that generally speaking, things are supposed to be viewed in an objective standard and not a subjective standard. I think you have to recognize that delays in procuring materials that would otherwise be viewed objectively as the contractor's problem will not be viewed objectively as the contractor's problem today. As architects, where we're often the initial decision maker, I think we're going to have to step back from the project a little bit and try and view this exceedingly objectively and find out that under the current circumstances, could a contractor have procured these materials? And if not, what would that delay look like? And then populate those delays into a critical path schedule. If the delay in securing materials has nothing to do with an activity on the critical path, I would not grant an extension of time. If it is clearly an article on the critical path, then I think you are probably going to have an obligation to grant that extension. Then the next question is whether that extension is compensable or simply excusable. And that opens up a Pandora's box of issues that we can't get into on a webinar.
Any other comments on that question?
Another thing to be aware of is just not necessarily it's not necessarily implicit in the A201, but it's often explicitly stated by the parties in the contract and added into, or it is implied that there is a duty to mitigate damages. So I think you need to look at it from both sides, whether or not steps are taking under the circumstances to try and mitigate some of the potential impacts. That's another thing to be looking at.
Okay, great. Thank you very much. The next question I'll direct towards Kirk and Michael, but I encourage everyone else to chime in as well. This question could be its own seminar. But after the pandemic is over, what do you see the economic toll on the architectural design field in New York State? In addition, how are you preparing your firms for such an economic impact?
Boy, that is a loaded question. I'm sure Michael will have as much insight as I do, because I haven't quite found that crystal ball yet, but it is a great question that a lot of people are asking. I'm going to give you the optimistic viewpoint, which is we went into this whole challenge with an unbelievable economy and a high volume of workload. On the surface, if we can come out the other side of this with some practices in place that allows us to keep proceeding forward, in theory, it looks like we should be able to get back up and running with solid footing, restarting projects and continuing the design process. I think there's going to be some design industries. Building typologies are going to suffer a bit, and one of the biggest ones on that list is healthcare. At least in upstate regions, hospitals are underserved right now, and they're bleeding money, unfortunately, and we're concerned about that. So people that are doing healthcare related work, it's going to be a bit of a challenge for the foreseeable future. Other projects, I think, are well suited to keep moving along because there's money budgeted for those. One that comes to mind are school projects. Some more community-based projects, I think, are going to maybe suffer in the short term from some jurisdictional approvals and other things, and have kind of been backed up because of labor shortages and other things. But I would like to believe that optimistically, with some hurdles to overcome, that we're going to be able to get it back up and running. But there's going to be some spotty challenges for a long term here for everybody.
Yeah, and I think Tara had the right answer before when she said it depends.
Exactly.
Because I think, as we've all seen, there are New York is going to have an enormous budget deficit. The states, unlike the federal government, have to balance their budgets. And so would it surprise me to see enormous cuts in spending from the state and then all the municipal subdivisions that follow? Of course not. There's also talk about another $1 trillion stimulus bill that may plug that gap. We just don't know. But I do think there will be many budget cutting measures. And unfortunately, I think a lot of that will be in capital construction.
Any other comments on that question? Yes, that is definitely another topic that warrants a follow-up seminar. Thank you very much. Those are all the questions that I received. So I would like to thank you all again for your work on this panel. It was really informative, really wonderful. And I'd also like to thank AIA New York State for your hard work, and the AGC New York State for your hard work in assembling this wonderful team of experts. Thank you all very much, and please stay safe and fill in your cards. And there is a survey that's listed, surveyconstantcontact.com survey. Please go onto that and complete the survey. Thank you.
Can I ask a question?
Yes, please.
I had registered for this workshop yesterday or a day or so ago, and when I went to join at the beginning of the time frame, the limit had been reached, and I was not able to join until just a few minutes ago. That was kind of frustrating. Is there a way of ensuring that once you register, you can get on to the webinar?
Mm-hmm.